Welcome to the hearing on the Subcommittee on Antitrust, Competition Policy, and Consumer Rights. Today we're pleased to have with us some distinguished guests, world-renowned witnesses who will be talking to us about whether the United States has a monopoly problem. And we're very grateful to each of you. We know how busy you are and how valuable your time is. We're grateful for your willingness to share it with us, and also your willingness to prepare your written remarks, which have been informative. Americans have long had a very understandable aversion to bigness, to the concentration, the accumulation of power and wealth in the hands of the few, whether it's the size of government or the size of industry, the size of particular players within a given industry. Concentrations of wealth and of power make Americans uneasy, and rightly so. It's therefore not surprising that we're currently engaged in something of a national debate on this very topic about whether, or to what extent, in what ways, the United States has a monopoly problem. Virtually every week, a newspaper or magazine or broadcast news media outlet will carry a story or editorial suggesting that the economy is now being dominated by monopolists. In popular books and on cable news, pundits often lament the curse of bigness, arguing that concentrated corporate power is hurting small businesses, increasing inequality, and ultimately doing things that may tend to undermine the republic. In my view, much of this conversation is perhaps primarily about the growth of a few tech companies and their importance in many people's everyday lives. These companies have, in many instances, changed the way people buy and the way people sell pretty much everything. They have changed the way we consume news, certainly, and they've changed how we communicate and with whom and at what times and what ways we communicate. It's no longer an exaggeration to say that in the last 15 years, companies like Facebook and Twitter and Google and Amazon have fundamentally transformed life for many Americans. Increasingly, people look at the conduct of these companies and they start to worry. They worry about whether these companies protect user information. They worry that these companies fail to police conduct that may occur within their respective platforms. On my side of the aisle, among Republicans, many worry that these companies might discriminate against conservative viewpoints. And I share many of those concerns. And I share the desire, certainly, for solutions. Congress has many tools at its disposal. What I don't share is the enthusiasm for using antitrust to address these problems. Calls for stricter antitrust enforcement are often too abstract, and this applies far beyond the concerns raised today about the tech industry. First, much of the commentary fails to engage with the evidence for and against the proposition that the economy in the United States today is controlled by monopolists. Instead, it seems almost to take that point as if it were somehow self-evident. But in reality, people may disagree on whether economic concentration has significantly increased over the years. They disagree over whether concentration reflects more or less competition in the marketplace. They disagree about whether antitrust policy either could or perhaps should do more to address economic concentration, including whether conduct by large firms should be challenged because it affects competitors rather than consumers themselves or competition itself. Second, it's not enough simply to say that antitrust enforcement simply needs, in the abstract, to be more aggressive. If antitrust has, in fact, been too lax, then we need to know the specifics about what that means. What specific practices are occurring? And how are those practices harming consumers? What specific remedies under antitrust law might be taken to remedy such abuses? And we'd also need to know what specific details have been allowed to proceed unchecked, and what the agencies charged with enforcing these laws might have failed to consider despite the information that they alone had in analyzing transactions that they themselves have approved. Third, antitrust law is not properly viewed as a sort of Swiss Army knife of a policy tool, one that's capable of addressing and solving a whole host of social ills, of public policy woes for which other laws have been inadequate. To my mind, this kind of an approach, the Swiss Army knife approach to, or I should say maybe the magic Swiss Army knife approach to antitrust law, fundamentally misunderstands the purpose of antitrust. Properly exercised, antitrust enforcement should police inappropriate exercises or accumulation of market power. And in doing so, antitrust should serve the interests of consumers, of competition itself, rather than the interest of individual competitors. However, as we discussed at one of our prior hearings, some are calling not only for more antitrust enforcement, but for an expansion of the goals of antitrust itself, which would return us to a past in which overtly political considerations tended in many circumstances to drive antitrust decisions. We should be reluctant to do this on either side of the aisle. From any point along the political ideological continuum, we should be very reluctant about that impulse. Congress has other policy tools to address many of these other concerns. For example, we know that efficiency-enhancing consolidation can, in some cases, result in job losses. One option is to block mergers based on the potential impact that the merger in question might have on employment. Another, I believe, better option is to devise better policies to promote work itself, to promote the kind of economic activity that leads to more jobs. That's my preferred approach. More importantly, many of the concerns that some would like antitrust to address involve inherently different political decisions, decisions that should themselves be made by Congress rather than antitrust enforcers, rather than by the agencies charged with enforcing these laws or the courts charged with interpreting them. Efforts to add such considerations to antitrust policy are simply a means to circumvent the role that the legislative branch is supposed to play in favor of the subjective political goals of activists, of unelected bureaucrats, and a handful of others. Weaponizing antitrust enforcement to police subjective concerns rather than the objective concern for consumers would have very broad and serious repercussions, especially when antitrust policy is wielded by one's political opponents to achieve their own subjective aims. Finally, I should add that before we consider changes to how antitrust policy is formulated and how antitrust law is enforced and applied, we need to keep in mind that these decisions will have very serious consequences on our country's economy. This suggests that we show some humility in how we approach this work, about our understanding about how markets function, particularly before we condemn economic activity that appears to benefit consumers, bringing down prices and increasing options and quality. A final point, of course, large firms can and do act anti-competitively in some cases. Of course, some mergers are anti-competitive and should therefore be blocked. But as Professor Herbert Hovenkamp has cautioned, if we view the monopoly problem as political but fail to provide a roadmap for analyzing specific practices, it's just a recipe not just for ineffectiveness but also for capture by special interests. We should therefore keep our focus on the consumer and demand that alleged anti-competitive behavior be explained in terms of how that anti-competitive behavior impacts consumers.